This is Barry's Zalma on insurance. The jeweler's block policy is a special type of inland marine coverage that provides indemnity against certain risks of loss suffered by a jeweler who carries very expensive property. It had its origin about 1920. And since that time, the policy and the proposal or application upon which it is based have become more or less standard. The Inland Marine Insurance Bureau, of which most insurers who offer jeweler's block insurance, prescribes contracts and proposals for such policies that are identical for all Bureau members. The Bureau forms for proposals and policies used in the jewelry business are accepted in every state. Under the standardized system of issuing a jeweler's block policy, the merchant executes an application called a proposal, which is submitted to the insurance company and often reviewed by the Bureau for purposes of establishing a rate and approving issuance of the policy. When the rate is ascertained and the policy issued, the policy with the proposal attached is sent to the local agent for delivery to the insured. Now, you would think that an easily read insurance policy would cause little trouble, but there are many pitfalls to the person insured by a jeweler's block policy, and some of the common problems faced by the insureds include a lack of adequate books. The jeweler's block policy is an inland marine policy that covers against the risk of loss of highly valuable movables, jewelry, gold, and gemstones. Since most gemstones and valuable metals are fungible, there is no way to identify one diamond from another without a laser engraved serial number. Theft and fraud is fairly easy. As a general condition, a jeweler's block policy will contain, as a material condition precedent and subsequent, an iron safe clause that requires the insured to maintain records sufficient to establish the exact amount of loss. It's called an iron safe clause, although the words don't appear in most jeweler's block policies, because in the early days of insurance in the United States, merchants were required to keep their records safe from fire by locking them every night into an iron safe that was fireproof, and that required the insured to maintain records sufficient to establish the exact amount of loss. Lloyd's issues its own jeweler's block policy on a form O(L), and its conditions include an iron safe clause that provides the assured shall maintain and keep detailed records of all purchases, sales, and other related transactions, including purchase and sales invoices, customers' goods, and goods of others in the jewelry trade, stock away from the premises which shall be listed separately, maintain and keep all jewelers' memoranda and consignment agreements, take and record dated physical count inventories at not less than 12-month intervals, and the records and documents required shall be kept and maintained so that the underwriters can accurately determine therefrom, for each item, ownership, acquisition date, the assured's cost price, the sale price and date of sale, the estimated value of customers' goods, the value of goods of others in the jewelry trade, and the exact amount of any loss or damage without reference to the personal knowledge of the assured or others, and without reference to accounting calculations based upon information or material other than a combination of the records required by the policy. Now, commonly, jewelers maintain a perpetual inventory on index cards, in loose-leaf books, in ledger books, or on a computer database, and then take a physical inventory annually to reconcile the perpetual inventory. Problems generally arise when the perpetual inventory is not reconciled on a regular schedule and the jeweler fails to reconcile errors in recording purchases or sales, expected shrinkage, or undisclosed and undiscovered thefts. When an insured fails to reconcile the perpetual inventory regularly, errors in entry and shoplifting losses will continue to be carried on the books of the insured, as if the gemstones still existed in the inventory, although they were sold or stolen in the past. The insured will inadvertently present an inflated loss to the insurer, or will be carrying an inflated inventory on his books. At the time of loss, it will be impossible to determine exactly what was taken, since the records are unreliable. A New Jersey court found no support in the record for the trial court's conclusion that plaintiffs substantially complied with the requirements of the policy, because the case before it was not simply a case where policyholders maintained an inventory list which was sloppy or deficient in some respect, not material to the claim. Rather, plaintiffs maintained no records at all that could be fairly described as an itemized inventory or a detailed listing of traveler's stock. Therefore, plaintiffs could recover under the policy for the alleged theft at the trade show only if the court completely disregarded the record-keeping requirements of the policy or found them to be unenforceable. And therefore the court in Sherwood Products versus Connecticut Indemnity, a 2002 decision of the New Jersey Superior Court, the insured recovered nothing. Because many sales in the jewelry business are for cash, jewelers may be tempted to make sales off the books. Sales taxes are not recorded or paid. Income is reduced to avoid payment of income taxes. The cost of goods sold is recorded as a greater percentage than reality. Tax returns, usually accurate and reliable documents, become as unreliable as fiction. In a case where the insured jeweler's continued failure to provide the insurer with the requested inventory records, purchase records, list of property allegedly lost, information as to the jeweler's availability for an interview, and the failure to appear for an interview without a valid explanation or excuse, constituted a material breach of the policy which precluded plaintiffs from recovering anything for their loss. Some jewelers, in fact, refuse to update their inventories to comply with value changes in the merchandise, and therefore may be carrying gold on their inventory that was purchased dozens of years ago at $100 per ounce and is now selling for $1,800 more or less an ounce. Since the policy limits the liability to actual cash value or the smallest amount appearing on the insured's books, By not updating his or her records, the insured will, in the event of a loss, fail to recover the actual cash value of his loss. The Lloyd's Jewelers Block policy provides for actual cash value, but states, quote, "in no event exceed the lowest figure put upon such property in the assured's inventories, stock books, stock papers, or lists existing at the time the loss or damage occurred." Close quote. It is therefore wise for an insured to update his or her inventories to market value, because the value of jewelry and precious metals has been fluctuating greatly in times of inflation. Jewelers often discover loss when they take a physical inventory of their goods, only to find less jewelry present than their perpetual inventory says should be there. Provisions in a jeweler's block policy as to maintenance of a safe on premises and the keeping of an itemized inventory were found to be promissory warranties as well as conditions, and an insured who had no safe on premises at the time of the theft and who had no itemized inventory of items on premises was not entitled to recover for loss because of theft. This was a decision called Damron versus Fireman's Fund, a 1968 decision of the Texas Court of Appeal. When a jeweler's block policy required the insured, Stafford, to keep a detailed and itemized inventory, and he failed to comply with that provision of the policy, coverage did not apply to the loss of a diamond, and Jewelers Mutual was dismissed from the 2006 lawsuit he brought into the Sixth Circuit Court of Appeal in 2014. The mysterious disappearance or unexplained shortage of the policy's exclusions section bars from coverage loss resulting from stock-taking losses, unexplained shortages, and mysterious disappearance. Nearly 3 years after the disappearance of the jewels, there has been no explanation as to how the 2 bags could simply disappear from the insured's vault. Therefore, coverage is additionally barred by this section of the policy, and the court found that coverage of the jeweler's claim loss was clearly barred under the jeweler's block policy in a case called Astoria Jewelry versus N. Barquette, a decision of the District of Puerto Rico in 2003. Now, the jeweler's block policy also contains an exclusion for entrustments. The plain language of the dishonest entrustment exclusion confirms that the exclusion applies to the present case, Abrams versus Great American Insurance Company, a 1935 decision from the state of New York. The loss of plaintiff's jewelry resulted from theft or an act of a dishonest character on the part of persons to whom the jewelry was entrusted. It is irrelevant to whom or for what purpose the jewelry was actually or intended to be entrusted. Entrustment is to be determined by the state of mind of the insured rather than that of the recipient. Jeweler's block policy also will invariably contain a requirement that the insured maintain protective safeguards to protect the insured from many types of losses. Security of the premises has always been an important aspect of underwriting a jeweler's block policy. Failure to have any of the devices promised in operational order simply causes the policy to be void during the lack of such protection. Lloyd's added interesting exclusions to the 1995 OL policy that should be carefully studied. For example, having the combination to the safe or alarm written down anywhere in the store can cause a claim to be denied. This and other new exclusions deal with adding protection to the merchandise and give the insured more incentive to protect his or her property. When I studied to be a agent of U.S. Army intelligence, one of the things we were taught in how to find an access to a safe was to look at the last page of a person's diary, where they usually would write the combination down. I've also seen cases where the combination to the safe was written on a Post-it note that was attached to the door of the safe. In Phoenix Insurance Company versus Ross Jewelers, a 1966 decision of the Fifth Circuit, the court found that the provision of a standard jeweler's block policy that the assured would maintain the protective devices described in the proposal was a promissory warranty as well as a condition. In that case, one of the protective devices attached to the vault was an alarm system connected to a police station. The system was activated or deactivated by a key. On leaving the store at night, the manager activated the system but left the keys in the device. When burglars entered the store that night, they simply turned off the alarm with a key conveniently left in the mechanism, broke open the vault, and stole more than $65,000 in jewelry. The court held there was a breach of the policy requiring maintenance of the alarm system, and that, in the absence of estoppel or waiver, the breach prevented recovery for the loss of jewelry taken from the vault. This video was adapted from my book, Selma on Insurance Claims, Part 104, 3rd edition, which is available as both a Kindle book and a paperback, and is one part of the 10-part treatise, Selma on Insurance Claims. It is, along with its brother parts, available as a Kindle book and or a paperback from Amazon.com. Please subscribe as well to my YouTube channel and my Rumble channel, clicking on the like button or the Rumble button as you do, and subscribe to or sign up for my Locals channel, my blog, and my Substack publications so that you can learn of future videos and future blog postings. Thank you for your attention.